2019 commission meeting.
Sorry, Mr. Chair.
And that's all right. Christina, would you read the Open Public Meetings Act, please, statement?
Of course. Good morning, Commissioners. Good morning, everybody else. Adequate notice of this meeting of the Pinelands Commission was given in compliance with the requirements of the Open Public Meetings Act by providing notice to all municipal and county clerks within the Pinelands area and to the Secretary of State on December 21st, 2018, and to the Commission's officially designated newspapers on December 20th, 2018, and by posting a copy on the Commission's website.
Thank you. Nancy, could you call the roll, please?
Good morning.
Good morning.
Commissioner Ashman, Commissioner Avery, Commissioner Christie.
Here.
Commissioner Erlin,
Here.
Commissioner Howell, Commissioner Irick,
Here.
Commissioner Janarone, Commissioner Lloyd,
Here.
Commissioner Lovauer,
Here.
Commissioner Pikaliski,
Here.
Commissioner Quinn,
Here.
Commissioner Rowan Green, Chairman Prickett.
Here. Would everyone please stand for the Pledge of Allegiance? Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Okay, our first order of business is to elect the election of the vice chair. Currently, our vice chair is Alan Avery. He is, I think, trout fishing today somewhere in the Adirondacks.
Traveling to Colgate for an alumni.
He indicated to me that he is interested in continuing to serve. I think he's done a great job. But
I'd like to renominate Alan Avery if I could, please.
okay. All right. Are there any other nominations? Okay, all in favor of electing Alan Avery to be vice chair for 2019, 2020, that year? Say aye.
Aye.
Anybody opposed? Okay.
Congratulations, Alan.
Yes. Committee assignments. Has everyone received, is there a sheet for committee assignments? Okay, great. I don't think it's, okay. Excellent. Any questions about committee assignments, especially if you don't, it's basically the way it was. Very few changes. We had to, with our new commissioners, we added to some committees. But I just wanted to say that if you're uncomfortable, you don't have time in the future, or you want to make adjustments to your assignments, let me know. I'd be glad to look into that possibility. Okay, but I just
I haven't been notified.
well, you were what you might want to do is look at the committee.
For committees, but
You can't get out of it, Dan.
I didn't want to not show up for something.
No, it's by, I sent out a email asking if commissioners were interested. And so if you want to take a look at the subcommittees and you have something you're interested in, let me know.
Is everybody on at least one?
No,
No. Okay.
yeah, not everyone is not on at least one. So I would say that, some commissioners are way too busy to, be on a committee. They have a long ways to travel or, just don't have the time for one reason or the other. So I appreciate commissioners that spend their time and, come to these meetings, commission meetings as well as committee meetings. So thank you. Okay, next order of business is the adoption of the minutes. And we have the open minutes, and we have, let me just, part 2 of the closed session minutes. We're not going to do the part 1 closed session minutes today because we wouldn't have a quorum for that. So I'm looking to adopt the open minutes for June 14th, 2019. and also the closed session minutes, part 2.
So moved, Chairman.
Thank you.
Chairman, before you get a second, I was not here on June 14th, but I have read the minutes and they're acceptable in my mind, so I will be voting on it.
Very good. Okay, great.
Are we voting on the closed minutes as well?
Just part 2, part 1, which I believe you recused on.
So I
for sake
can vote
of
on
August. So, did we have a second? I'm sorry. Second, thank you, Dan. Are there any questions, concerns? Okay, all in favor to adopt the June 14th open session and closed session part 2 minutes, say aye.
Aye.
Any opposed? Any recused? Okay. Any abstained? No. Thank you. Okay. Committee reports. The P&I meeting met this last week, I think it was. And here it is. I've got way too many papers. We'll put them in here. The CMP Policy Implementation Committee met on June 28th, 2019. And the committee adopted the minutes from the May 31st, 2019 meeting. The committee discussed and endorsed the Pinelands Infrastructure Trust Fund, PITF Master Plan Amendment for projects funding. A public hearing on the amendment will be scheduled for July 31st, 2019. The committee discussed draft CMP amendments for coordinated permitting for those private development applications that qualify for Board of Public Utilities preemption from local review. The committee discussed draft Kirkwood-Cohansey water management goals and policies. Does anybody have any questions? Any input from the meeting or anything? Okay. All right, next order of business is executive staff reports. Nancy?
Sure. We are continuing contract negotiation for the period that I guess began July 1st. So we're as close to on schedule as we have ever been, because we're usually years out. So, and we have been meeting, we've been meeting scheduled for Monday. So I think that should wrap up relatively soon. So that's good. The climate committee meeting, very long name, is scheduled for next week on the 17th. Staff and I, led by April and Evan, had a meeting with Esri, who is the big supplier of GIS, all great things GIS, software, databases management, about things we have, things we might need. So we are pursuing thinking as we are ever increasing our abilities to handle data and produce maps. We'll start to see more and more of it. We're finally at a place where that's starting. We also met with Department of Environmental Protection and their land use program and their IT people to discuss their new online permitting and how they're doing it, because we were interested in moving that way. And that was fascinating. And we learned a lot. So you'll be slowly but surely seeing more and more from us in that regard. And that's where we're focusing a lot of effort now and trying to get ourselves up to speed. April's been helping leading the charge with Evan. So that's all exciting and good. I attended a meeting at DEP that was basically called by Assemblyman Dancer. You may recall that last summer, the governor signed the Prescribed Burn Act, which was really intended to increase opportunities for prescribed burning in New Jersey, mostly the private landowners, for them to do more, to sort of take away some of the liability associated so that private landowners would feel more comfortable doing it. DEP has to do rulemaking. So Dancer called the meeting basically to get a status. So it was a lot of DEP people, the assemblymen, John Bonnell and I attended, Audubon was there, PPA was there, you know, a whole group of people. It was a good discussion. DEP hasn't started the rulemaking yet. They're hiring someone who's going to do the rulemaking and do like this. They're hiring a retired DAG to come back part-time to write the rule, which makes some sense, you know, that's all they'll be doing, but it'll still take them a while. And they've done some things to start to think about prescribed burns statewide, looking at all their areas, but not a lot. So that was a good meeting. The Assemblyman was sort of pleased, and of course, as always, at the end of the meeting, the last one to usually speak is the Pinelands Commission, where we had to inform everyone that we do exempt prescribed burning, but the bill incorporates into prescribed burning land management, thinning, clearing, and we don't exempt that. So I said, any rulemaking, anything going forward, we have to remember that, include it, make sure it's part of the process, because our rules do not exempt that work. So that's always the thing that leaves the whole room going. But so that was good. It was good we were there and part of the conversation. So that was a good meeting, and I'm sure there'll be more of that. And other than that, that's all I have.
Very good. The standard that we have in the CMP does include prescribed burns, so that's a good thing, I guess. Maybe that's where they got the name at, or they were referring to the CMP. Nancy, I have some questions. Does anyone have any questions for Nancy? Okay. First question I had was having to do with the enduro races. And I was curious about the process of putting together a permit. I know you have to measure how many miles are in the enduro race, but the background information on the permits talk about sand roads, fire cuts, and trails, and also the use of public land, at least I think in both cases. So I was just curious how staff processes these permits and the time it takes, and whether there's any feedback, any monitoring of the events.
So you may remember that as part of plan review, the enduros came up in a pretty big way. And we had a lot of public interest in it. And at the end of the day, we didn't make any CMP changes, but we made some internal changes, I think. But to give us added a little more meat on the bones with some of the language. So I don't know, Chuck, if you want to go over it, Brian Zor's here. He does all the rec permits. So however you're planning on doing this.
Thank you, Chuck.
Good morning, commissioners and members of the public. So under our regulations, an application has to be filed for a recreational vehicle event in the Pinelands. And the applications come into the Pinelands for these events. Typically now they're submitted in an electronic format, as opposed to over the decades they came in paper copies. Oh, okay. I'll back up. So recreational vehicle events, from a permitting standpoint, which is my bailiwick, I think, are much different than commercial development in the Pinelands. So if I'm going to develop in the Pinelands, you're filing an application to develop, we're reviewing it for all the standards in the Pinelands Comprehensive Management Plan. Recreational vehicle event authorizations are somewhat different. They're for typically occasional events that happen 1 or 2 times in the Pinelands per year. And the applications are submitted, and our staff, in particular Brian Zora, will review those applications to ensure that it's consistent with the standards of the Pinelands plan. It's much different, though, than reviewing something that's proposing commercial development in the Pinelands. So when we're reviewing these applications for the recreational vehicle permits, we're ensuring that they're staying on existing roads, be they paved, sand, on existing trails that are of sufficient width to accommodate these recreational vehicle events, and ensuring that protection of threatened and endangered species locations that we know of. We site inspect not every recreational vehicle permit, because obviously when you're doing a 60-mile route, that takes a lot of time. And the permits that are issued, that you've seen 2 of them in your packet this month, indicate that the event is to occur on existing trails, fire cuts, and sand roads. Typically, no new routes, no new clearing is proposed as part of a recreational vehicle event. If it was, we would require an application for that. Once we issue our recreational vehicle authorization, the applicant is obligated to secure whatever permit may be necessary from the public agency, typically state parks lands. The Department of Environmental Protection may in fact have other requirements, other limitations that they can superimpose over the routes. Typically that coordination happens with the applicant prior to us issuing such the recreational vehicle permit. The events are conducted. The commission staff typically does not site inspect after the events. When we do receive reports, and we do receive these, of alleged violations of the route that was filed with the commission, we do site inspect, we do coordinate follow-up with the Department of Environmental Protection. A similar statement that I'm going to make that you've heard in other instances, we do not have direct enforcement authority. We do partner with the Department of Environmental Protection. On occasions, the Department of Environmental Protection does sanction a club if they've violated their permit. Typically, the sanction that we've seen is limiting the number of events that club can conduct in any given year. And we fully support DEP in those matters. I'll stop and be glad to answer any questions.
And what kind of vehicles are
They are typically motorcycles. We are familiar, I think everyone's familiar, occasionally they are Jeeps and four-wheel drive vehicles. Brian, did I miss any types of vehicles?
That's all we really get. Every once in a while, we'll also get what's called a hare scramble. So the events that Chuck was supposed to talk about are called enduros, which are a specific type of event. There are also Jeep events, and then hare scrambles are usually on a particular time parcel where you can get flies as well. So there's little drive for the four-wheel.
And just so everyone knows, that's Brian Zora of our staff.
Hi, Brian.
Chuck, typically, how many miles are these events when they come in?
Brian, would you want to offer?
To be an enduro, they have to be, I think, between 70 to 80 miles, and that's part of there's a national group that kind of monitors, and it's a they set the regulations, it's their own internal club kind of thing, but so typically between 70 to 80 miles, and that's what they have to have an enduro. With the enduros, they're not whoever can get there the fastest kind of races. They're actually timed so that they have to be at certain checkpoints at certain times. So if they're too fast at a checkpoint, they get docked points. If they're too slow, they get docked points. So it's the way that they monitor these are it's not just a race. So it is sort of a more minor kind of event.
So the length requirement is determined by an outside agency. We don't have any regulations on that.
Right. I mean, we would, if anybody applied for any, organized off-road event, no matter what the mileage was, we would review that. But that is typically what they do for their enduro.
Sure.
Chuck, when they lay out their enduro, after they've received a permit, they lay out their trail use for Brian. My understanding is that they mark the trail, like with banners or signs or something to show the riders this way, not that way, right, throughout the length of the track. Do we require them to remove these signs and banners and things after the race is over?
That we do not, the commission. Brian, do you know whether DEP requires them to?
Yeah, as part of their special use permit that they issue, they always have a requirement to clean up, take down signs. They'll often have people, they have to go through and pick up trash. And the majority of these do happen on state park property. And then they also have to send a crew usually to rake if there's any areas where there's a stone or something, they have to rake back the roads to grade them.
All right. And would we consider it a violation of our permit if they fail to honor that requirement of the states to remove their signage or clean up their trash?
I don't think that's a violation of our regulations, but I think we would partner with the Department of Environmental Protection and to support them if that violation of sister state agency's permit occurred. But again, in the absence of enforcement authority, our ability to sanction is somewhat limited.
No,
But
That's
we partnered with DEP in prohibited groups.
Correct.
okay.
What do you mean prohibited groups? I'm sorry.
In my introduction, I mentioned that on occasion that DEP, it has been determined between commission staff and DEP that a group altered its course for whatever reason. And sometimes these alterations from the group standpoint are legitimate. An area was flooded, so they went around it and created a new route. Sometimes they are not legitimate. And DEP and our staff has site inspected, determined that they have violated the condition of our permit, that they follow the route that we approved. DEP has made a similar determination. DEP has with our support, issued a letter indicating that they are sanctioning the club and limiting the number of events that they can conduct in any one calendar year. Correct.
So in those circumstances, we withhold the permit. And that's really what I was driving at, that if we were to find out that an organization had violated the terms of their permit, whether they be our terms or the DEP's terms, that we could then withhold a permit at a subsequent from them as a form of enforcement, since we don't have true enforcement powers.
Your staff has wrestled with that. There have been instances where clubs have violated the route, and we've required them to have monitors in subsequent events to ensure that in fact they follow their routes. But my observation would be, in the absence of regulations, it becomes difficult. But we have imposed those conditions on events.
We can impose, I'm sorry.
Hold on. Eric?
Does the applicant have any responsibility to sign off that they have in fact restored the trail?
In instances where there's a violation, we require the applicant to do the restoration and receive, I don't want to say the commission's formal approval at a meeting, but yes, they need the approval that they have done the restoration and resolved the violation.
Should we, as a matter of routine, ask the applicant to sign off and indicate that they've restored the area properly? So that in a subsequent inspection, if we inspect and find out that that's not the case, we have some ammunition for future applications?
Well, we certainly can ask that question.
Thank you. Ed? Yes. We could condition our permit on compliance with DEP or any other required permit, couldn't we?
Yes.
Okay.
Dan?
Would you explain enforcement? You brought enforcement up a couple of times. We don't have the authority to enforce permit regulations.
We have no enforcement authority.
Okay, so would you explain where the enforcement authority comes from on each level?
All right,
I mean, I'll defer to you.
Let me
But
take it from there.
Let me do the broader. So I think it's important to note that the lion's share of what the commission and the commission staff are involved with are land development applications. And recreational vehicle permits are a very, very small slice of the pie. But in the context of land development, our regulations, the Pinelands Comprehensive Management Plan, does not provide any direct enforcement authority. So when we issue our certificate of filing, an applicant proceeds to a municipality, receives approval for its convenience store, they go out and they start developing the convenience store and they fill wetlands. And there's always an exception to every statement. They fill wetlands. We are contacted frequently to issue a stop work order. We do not have that authority. We cannot issue stop work orders. We cannot impose a fine directly on an individual. What we do in that case is we contact the municipality, the zoning officer, the construction code official, the municipal attorney, and ask for their assistance in taking action to stop the violation. Typically, that's a violation notice from the zoning officer, and in more egregious instances, they will issue a municipal court summons. That's our direct way of, and most efficient way of trying to resolve violations. I'll let Stacy talk in a minute about other legal recourse. The only other thing I wanted to mention, to bring it back to recreational vehicle permits. So that becomes a little more difficult because we don't have a municipal zoning officer to call. We don't have a municipal construction code official to call. Stacy?
So, as you know, the way the Pinelands Protection Act works is supposed to be a joint regulation of development of the Pinelands between the municipalities and the state. So, unlike, for example, freshwater wetlands, the Department of Environmental Protection, we do not have what's called civil administrative penalty authority. We cannot assess an administrative order. We cannot issue a civil administrative penalty where you can seek penalty or fees for every single day that a violation continues. And that's the norm with regard to environmental enforcement. For whatever reason, probably because of this joint regulation model, the legislature decided not to do that. So what Chuck is talking about is the fact that when we adopt, or you adopt, an amendment to the comprehensive management plan, the act requires that the municipalities in turn amend their master plan and land use ordinances to make those changes. They're obligated under law to do so. It doesn't mean they do it timely, but they are obligated under law to do so. And therefore, when there is a violation of the comprehensive management plan, it is also a violation of the local land use ordinance, and therefore the municipality can act. However, there are times when the violation is so egregious, and we have one right now, which involves a matter in Winslow Township, where there is it's a removal of soils issue. There is a municipal court action going on, but because of the nature of the violation, we can run into court, into Superior Court, and ask that the court determine that there in fact has been a violation and seek damages on behalf of the Pinelands. That is not a civil assessment. That we can't.
The state does.
The state runs into court, exactly.
Do you want to talk about the difference between damages and civil penalties?
Yeah, and we're kind of getting into that area where the commission wants to receive attorney-client privilege advice. We're definitely dancing in that territory. I'm happy to do that in closed session. But there are differences. What was that?
Speak generally.
Yeah, I mean, there are differences between damages as a result of a lawsuit where the court makes a determination versus civil penalties that are assessed by a state agency.
So what we've done in the past, I won't speak about current matters, what we've done in the past, we've run into court, we've gotten a declaratory judgment, and the court then tries to fashion some sort of remedy to make the Pinelands whole. Have the property owner go back, restore the property, to take down the development that wasn't authorized. All different ways to try to resolve whatever the issue may be. But it's much easier, believe me, having worked for the Department of Environmental Protection, when you can send out an AO and a CAFA and start saying or imposing penalties.
You think they know what that stands for?
Administrative Order and Notice of Civil Penalty Assessment is an AO and a CAFA. And certainly that then leads to an administrative process, an administrative imposition of fees. Those matters are usually resolved through an administrative hearing at the Office of OAL, Office of Administrative Law. It becomes a much bigger issue. You have to get approval from the Attorney General's Office, Division of Law, to file a Superior Court case to seek that declaratory judgment. So that is why when we say we don't have enforcement authority, the reality is we don't have direct enforcement authority. We can't ask for penalties.
We could rescind the permit, couldn't we? I mean, it's an administrative process that I'm not sure is the most efficient one, but we could rescind the permit.
In most instances, I'm not saying we can't, although there's nothing in our rules that per se says that. In most instances, however, what we're having happen is people are not coming in for permits in the first instance, and that's the nature of the violation. So that's not an effective mechanism for us. ORV is particularly difficult, as you know, from plan review, and for those of you who are new, because the regulation that we rely on, I mean, from a Superior Court perspective, is the general requirement under recreation that route maps for organized off-road vehicle events shall be filed with the executive director. That is the extent of the provisions in the CMP with regard to ORV use. It's not extensive, it doesn't talk about permits, except to the extent that these route maps have to be approved. So, if you're running into Superior Court, that's not a lot for us to hang our hat on.
So the route map has to be filed with the executive director, but do they have to comply with the route?
They should, I mean, but it just says that the route maps have to be filed and approved.
But the document we issue says.
The document we
It has to go.
Yeah.
We filled every space we can fill. And we filled a little more when we had the plan review discussion. But the decision at that time was made not to keep going, because every one of these is full and excitable. But as I recall, on most of these routes, they have to let the state police know, or let some police know that that's happening.
Yeah, there's a lot of requirements they have to, well, obviously, they need the property owner's permission, we need to make sure they notify, have documentation, they notify all the towns. Some towns do require a parade permit or a special use permit, not all do, but like Washington, for instance, but they have to notify all the state police, they have to have insurance that has a permit commission that's additionally insured for $1 million, for us in case anything does happen. And, as Chuck said, in most cases, we see not paper copies of maps. I mean, there were a few groups that use paper copies because they're digitally challenged, which is fine, but most of them we get because the state's FARs also require that they have submissions to them in Google format, and so we get that as well.
Thank you. Thank you, Brian. Thank you, Chuck. You, Jerry?
Typically, how many vehicles are participating in these events?
I'll ask Mr. Zora to address that.
They can go, some of them are very small, and maybe have a dozen people, others go up to, anywhere 100, 150. I think the largest that I've been told is like 200. And these are, the way they do these are just, everybody starts at different times, so they have a continual stream coming out of different things. But that's, a lot of these groups too are people, there's maybe 5 or 6 groups that apply, maybe for 1 or 2 events each year. And it's kind of the same people that go and running these other groups, so, kind of the same players. But yeah, I'd say average probably 150.
Brian, I would estimate about 12 events per year. Would you agree?
So yeah.
Okay, I asked the question about the Enduros, just as an update. I know a few years ago there was some instances of riders going off course, and private landowners and different organizations were concerned about that. I was just really looking for an update because it has been quiet. It seems like the groups have been enforcing their routes, their compliance with the rules. So as a commissioner, I was just interested really in an update on the procedure and see if the changes that were made a number of years ago were working with electronic filing, which seems to have made a big difference. So again, Chuck, thanks. Brian, thanks. And Nancy, thanks for addressing us, as well, Stacy and also Christina.
And just to carry, not to let, we'll just keep this going forever. We have, we've heard from both the environmental groups and the off-road groups that, for the most part, it's the bad actors that are causing the damage in the forest. And in fact, I believe some of the off-road groups help participate with volunteers in terms of putting up the barricades in the sensitive areas. So the groups, and for the most part, I believe the groups that are following the rules are doing their part. It's the bad actors who are trespassing or not getting permits that are causing the damage in the forest. That's my 2 cents.
Good. Okay, are there any other questions for Nancy regarding any other items? I have another question, and it involves the no substantial issue finding with Barnegat Township Ordinance 2019-8. I found it, just would like some background on that. Usually municipalities, I think, like to keep runoff off their roads because of icy conditions and flooding conditions. But in this case, the code is requiring that discharges from roof drains and sub pumps be piped or directed to the street and away from adjoining properties. So I just thought that was a little strange, and I was thinking, is it because the lot sizes are small? Is this the most effective way to get water off the properties? And so
I'm not really looking now. I'm taking this one. So this is Larry and Brad. I don't know which order we're doing this in. Brad reviews them. Larry's running the place.
Susan Grogan usually is the one that deals with these things. Brad works for her, and what happens, this deals with the review of ordinances. And just a little background, because it's complicated. Susan did give a briefing to the commission a couple months ago, I guess it was. She's also doing it next week for the municipal officials. So if anybody's interested in hearing the briefing again, or for the first time, they're certainly welcome to hear it there. But the way that it works in the Pinelands, any ordinance, land development ordinance basically, has to be reviewed by the commission before it can take effect as law. If it hasn't been reviewed, it does not take effect as law. So we get arguably all the ordinances. I say arguably. Sometimes we don't see them. We see them years later, and those are sometimes issues. Most of the time we see them, and then we group them for efficient review in sort of three categories. And we use the term issue. Issue doesn't mean something bad, doesn't mean there's a horrible ordinance or anything like that. This means that it relates to the CMP so directly that we should review it. So issue is more of a substance procedure type thing. So we group them into no issue, no substantial issue, and an issue. Issues are the ones that come before the P&I committee for review, and we make findings, and they come to the commission, etc. So the ordinances come in and they're reviewed. Brad back there, he's one of the principal people that does this, and then he drafts a letter, and Susan then review it, and I sign them, we send them to the township. And in this case, the ordinance was found to be a no substantial issue. You know what that means is that it's stormwater, so it's related to the CMP, but we found that it didn't have any super bearing on CMP issues, and for a couple of reasons. First of all, in the Pinelands, stormwater is reviewed when it's major development primarily. And somebody doing, pumping out their sump pump in the basement to their neighbor's lot, while not necessarily something we want to endorse, isn't major development. So I think that Pride was the instance in here. And the other thing that's of interest in Barnegat's case, almost all the development that's occurred almost all the development in the Pinelands in Barnegat is Pinelands related. It's after the CMP was adopted. And they're big subdivisions, so we do see them. They are major development, and we review stormwater, and that includes how stormwater is managed on the roads, as well as how it runs off the property, goes to the roads, where does it go from the roads, it goes to the basins, how's it managed? And so that's part of the review that gets done. So they passed this ordinance and sent it in for us to review, and they put it in a different section than the Pinelands stormwater section. So now you have stormwater in two different sections, and sometimes that can be, I'll say, confusing to some people. What we have in the Pinelands section is that, again, it has to be, any major development has to be reviewed. But also there's a clause in there that says if there's any conflict, the more strict standard applies. So if there was a conflict, and then in a particular case there could be in some instances, but again, this only applies to new development. There was some concern that it applies to every house in Barnegat, but they clarified that for us. The ordinance is not artfully written that way. So, we reviewed it, and we thought that our certain existing standards certainly apply to it. So that's the reason we found it's a no substantial issue. It's a stormwater issue. It doesn't change anything because we have the review for major developments. And we wouldn't get so-called bad situations. So that's the reason it went out that way, and that's the reason it was reviewed that way.
Okay. Any questions? Thank you, Larry. I think this is probably the first time we've talked about one that is no substantial issue finding, but
Yeah, don't ever do that again, Jeff, by the way.
She missed it.
She said she didn't see any issue that's coming up to this meeting, so she thought she'd take off.
And I'm actually glad you raised it, because April and I and others have been talking about the packet and changing the packet, and somebody said, well, maybe we should stop putting that list in there, no one ever pairs. And you paired, so we'll keep putting it in there.
lo and behold. I noticed something interesting when I came here today. I came down Pembroke Browns Mills Road and turned onto Springfield Road. And I noticed on the left, there are two signs, and it says, please do not cut. And right away I thought, is that a township sign? You know, I thought of Robin, I thought of, and then I read further that there's flower bed there. But kudos to our roadside protection of wildflowers. Here's a citizen that is protecting the flowers on the roadside. And hopefully there's some indigenous pineland influence there. So, all right. Chuck, do you want to go next?
Certainly. I just have a couple of things that I wanted to mention. In your packet today, everyone hopefully noticed that we issued a letter of interpretation allocating over 60 Pineland development credits to a very large 6,000 plus acre parcel in Ocean County. I just wanted to note that was one of the larger letters of interpretations allocating Pineland development credits we've done. There have been a couple in the Woodland Tabernacle area in the distant past that were very large too. But in recent history, this was a very large letter of interpretation. I mentioned at the last commission meeting that we were working with Egg Harbor Township attempting to resolve a rather complex situation where a parcel had been deed restricted. The parcel had been subsequently purchased by Egg Harbor Township and annexed to one of their recreational areas. The deed restriction provided that the parcel could not be developed until a second parcel that was originally part of the parcel that Egg Harbor Township acquired. The development on that lot was served by public sanitary sewer. And as things go, everyone had anticipated that development would almost instantly be sewered and the deed restriction would be lifted from the 40-acre parcel that Egg Harbor Township had acquired. In fact, that existing development has still not been sewered. Egg Harbor Township has filed an application with the Department of Environmental Protection, Green Acres, for funding of their park. The Department of Environmental Protection understandably said, well, there's a deed restriction on this parcel that prohibits the development, and raised a red flag over the funding. We've worked with Egg Harbor Township, their engineer, their administrator. We're just about there to resolve the situation by relocating the deed restriction onto adjacent lands that are owned by Egg Harbor Township that are in fact vacant. So I think that's a good example of the different levels of government have worked diligently trying to resolve a matter, and we're just about there. And then one last issue I just wanted to mention that continues to, I've mentioned in the past, the difficulties with administering the municipal land use law and subdivision approvals and the period of protection from zoning changes offered by the municipal land use law. For example, if I receive final subdivision approval, I receive a 2-year period of protection from zoning changes under the municipal land use law, and then I'm eligible for 3 1-year extensions under the municipal land use law, and then we would overlay that with the Permit Extension Act that came into play between 2007 and in some counties out into 2017. So we've for the most part made our way through those days. The Permit Extension Act is over now, and Stacy Roth will appreciate this. We continue to work with municipalities that are providing a legal opinion to our office that once a subdivision is filed with the county and the lots are created on the tax map, that they can be built on forever, that they're not subject to rezonings. And that creates a very difficult position for us. So that if a subdivision was approved in the 1980s, it created 20 lots. Some municipalities and their legal counsel are advising them that those lots, regardless of zoning changes, are developable. And that does create a very difficult situation for applicants and the commission staff and the municipal staffs. That's all I had.
Any questions, for Chuck? Okay, Larry, do you have anything to report today?
Just a couple, I'm on the information that's been made project, virtual enhancing and we did meet the P&I committee on the virtual enhancing, good discussion. We're going to continue to think about it, make sure we have clear stances for all the questions. To reach that point, we were bringing back the rule of P&I, we did pretty close to the IKF, we also, and we're ready for public hearing at the end of this month. And we haven't received any comments, I think it's out there. We'll comments, we bring these back, finalize, and select the project. And the only other thing I want to mention is we were successful in purchasing a ground penetrating radar for our archaeology attorney. Marketing, trying to find sites for use. It's a very useful tool. Many times we'll look at a site and say, well, there might be archaeology there. Look, this is what we do. So we've had several days working that was a white spot this week. And then we're looking at a couple of different villages. We're down in the past.
Roman Florence.
There.
Roman Florence.
Roman Florence.
So we will be doing that in the upcoming years. So it's very useful to
Good. Any questions for Larry? Jerry?
Question, any consideration being given to including Pineland towns and Pineland villages in trust fund?
That came up several times earlier last year, I guess, and basically we committed to looking at the issue of the towns. And there's two aspects to that. One is that the original legislation that was passed and the voters endorsed was purely for regional growth areas. So we would need new legislation and a new bond and a new vote from the voters to endorse that. Well, we're committed to looking for that to possibly go through because a lot of the towns are very similar to regional growth areas in some ways. So we're interested in doing that. Villages are a far different animal, and I have to tread carefully here. There's a very sort of two schools of thought. The villages are frozen in time, if you like. Some people are ecstatic about that. Some people might like to see them a little bit more developed, in terms of being more, the state plan calls them centers of place. It's looking to see businesses and restaurants and things like that in villages, and we would not be against that, but there are some towns that would rather not see anybody doing that kind of thing. So we've had some opposition to almost anything involving villages. Villages under the CFP can be sewered, and so they, in theory, they might be interested in infrastructure funding, but boy, it's a mixed bag of who would be and who would not be. Also, about half of the villages in the Pinelands, the village management areas were the only ones that weren't designated in the original CMP. They were designated as dots. So that the extent of the villages was determined in partnership with the local municipalities. So those boundaries were drawn as a partnership between those communities. So they had to be established during the initial conformance process. But sewering is permitted there, but at very low intensities. The densities are permitted are very low there because the standard for villages is they shouldn't more than double in size. Essentially, it's a little more complicated. That's the basic parameter. So there were 100 homes there in 1980. At no point in the future should there be more than 200 homes there. So that was a long answer, but it's a little more complicated. So we are pursuing the idea of the towns. Hopefully sometime in the next year, we'll look at both aspects of that and see what can be done at the legislature and with the governor, because some of them need infrastructure. We've worked with, for instance, Buena Borough has a very innovative sewage treatment plant. Hamilton has an interesting sewage treatment plant. It has had a lot of ups and downs, but they're working with it pretty well. So there are issues in terms of wastewater in some of our major town management areas.
So we will be doing that. Villages, I'm not sure we have anything on that, right?
Thank you. On that note, I've had discussions with several South Jersey legislators about trying to put something forward this fall when we get back into session to see if that's something they'd be willing to consider. They're looking at it. I don't know how optimistic I am about it, but it is something that's on their radar. I mean, Hamilton has expressed a concern with it and is really pushing on their legislators to try to get it done.
Yeah, some of the towns have expressed interest, and some of the commissioners during the past year, Commissioner Galletta, notably among them, you're bringing it up now, so I think there's some support for it.
Mark, you have a question?
Yeah, thank you, Chair.
Good. Any other questions for Larry? Okay. Stacy.
Good morning, Commissioners.
Good morning.
First off, for Commissioners Pikliski and Lloyd, the reason Chuck named me during the non-conforming lot discussion is it's one of the things that sort of infuriates me. I do not know why municipalities don't understand that after the changes to the MLUL, there are set amounts of extension depending upon the type of development. And that is why there are things called non-conforming lots. And that is why there is something called zoning. So it sort of floors me every time we get this argument because it just makes no sense from a legal perspective. That aside, there were two things I did want to bring to your attention. First, with regard to the New Jersey natural gas appeals, PPA made motions. No, it's New Jersey. Oh yes, please. I forgot. Thank you very much, Commissioner Lloyd. If you would please leave the room. And just for the record, Commissioner Lloyd was nice enough to remind me that he has recused himself from the New Jersey natural gas matter because his law firm represents Sierra in that litigation. So this does not involve Sierra. This involves the Pinelands Preservation Alliance. They are a litigant with regard to two of the appeals, both the substantive appeal and on the Commission's approval of that pipeline, and a procedural appeal with regard to the process that was used, and also a appeal with regard to third-party hearing denial. So those are the matters that they are involved in. In all three matters, they filed a motion to take the order of two matters. They filed a motion to, that's right, because the procedural and substantive were combined.
The procedural has been fully briefed. The substantive and the third-party appeals are pending briefing right now. So they filed motions and those two.
Thank you, Christina. These things do start to run together a bit for me after a while. But they filed a motion to supplement the record to add the order from the South Jersey gas case, the order that remanded the matter back to the commission, and those motions were recently denied. So I did want to make you aware of that. So there will be no supplementation of the record. And as Christina pointed out, we are waiting for the appellants to brief, and so that the commission's response brief can then be filed. The other matter I wanted to bring to your attention, I've been working with John Bonnell, your chief scientist, and Nancy has also been very involved in this issue. We hit a bit of a snag in May with regard to the, yeah, can you get that back in? Thank you.
Thanks, Gary. We forgot about you, Ed. We were moving on.
So I want you to repeat everything.
We just started something.
Just started. So the science office ran into a bit of a snag in May when it went to do fish sampling with regard to the endocrine disruption study. In 2017, it has secured the position of the Medford Lakes Colony Club. It's unusual, but in this case, Medford Lakes Colony Club actually owns the lakes up to the low-high water line that they were going to sample the fish from. So it was an access issue. They don't own the fish, those are public trust, but they own the lakes. So in 2017, we had gotten an email response from the board, it is a volunteer homeowners association board, that authorized our employees and the federal partners, in this case USGS, to go out, do water quality sampling, do fish sampling. We are talking 80 fish, 40 fish.
Harvesting.
Well, right, sampling, they did advise that the fish were going to be collected and sent to a lab. Why they thought a lab meant they were like going on vacation, I can't explain to you. But in essence, when we went to, and before the club gave our scientists the approval to move forward with the study, John Bennell expressly informed them in great detail as to what was going to happen. So when they went to go out on the site in May, the office manager advised them that since they were going to be killing the fish, they were no longer comfortable letting them on the site. We are talking, like I said, 80 fish, 2 lake sites, 20 bass, 20 bluegill. Anyone who knows anything about angling, these are sports fish. They are intended to be fished. And for those of you who like those fish, they are intended to be eaten. But yet they're not threatened and endangered. These sites were, these 2 lakes, Mishimakwa and the lower Etna were identified because one is above the true sewage treatment plant. So they could see how these chemicals, and then they were also surrounded by development, so they could see sort of how these chemicals were impacting the fish. Then you would hit the STP, and then they were testing below the STP. They had already done 1 round of water quality sampling that had been sent out. So they've incurred costs with regard to this matter, and 2 years later, the current club now is saying they can't come on site. Nancy and I, the science office, Patrick tried to work through with the issue with the office manager. I tried in May to work through the issue directly with the board president, the current board president. They lawyered up, so now we are trying to work through with their lawyer. It does seem a little ridiculous. We've offered to replace the fish. We're working with them to try to get on the site, finish the water quality study, do the fish sampling next year because it has to be done before spawning season. They've already spawned. So I'm hopeful that we will be able to get this back on track. Because if not, we will need a new site.
It's very significant for us because we obtained a grant to do this work that now we can't do because they changed their mind. So it has the potential to become ugly because we're not just going to walk away from it. We can't. And we've incurred costs and we've got partners, federal partners, and all of those things. So we've been trying. We'll try nicely a little longer, like a week. No, we're done.
Do we have the option to choose another site? I mean, that's.
The difficulty here is there is no site just like that.
Because they needed to get above and below wastewater treatment plant to prove it.
Yeah.
We don't have another site. Is that
Yeah.
correct, Patrick?
Yeah, the only other site would be a river site. It is not as good as this. The other thing is they need the bats because my understanding is they want to compare their data with other data and other studies that have been done if they were done on bass. So there's a number of factors that is making this the perfect site for doing this stuff.
What would happen if you offered a 2-to-1 replacement?
The problem seems to be that they are troubled by the fact that the fish will meet their end in a nice way.
They had a change in board.
And I don't think, I mean, I'm open to any suggestion that the board is going to make to let us proceed. I'm just having some difficulty getting the message across.
I find the irony that the environmental agency wants to harvest and kill fish, and there's the private landowner fighting to keep you off the property.
Right, although to be honest, again, these are sports fish.
Understood. It's
Like share your.
just ironic. Role reversal. Somewhat. Yeah.
Okay, anything else? Any questions, final questions for staff? Okay, what's not on the agenda today is a resolution titled Expressing the Commission's Appreciation to Paul E. Galetta for his service as a member of the Commission between April 2007 and March 2019. I'd like to make sure Commissioner's okay that this is on the agenda at this point, add this to the agenda. Okay, so,
Chairman, don't we want to do this when Commissioner Galetta can be here to hear it?
well, I understand that,
I called Commissioner Gillette, I spoke to him, I told him that was the plan. He said, good. Tell everyone I said hi and I miss them very much. It's summer.
Bad time for him.
It is, right. It is the height of
I asked
blueberry
the same
season.
question, Mark. I was-
Right.
Shouldn't Paul be here?
He should be here.
We have 3 commissioners who are due honoring.
Yes.
We're doing them chronologically because Paul was the first and then Joe and Bob. So I did try.
Well, he should be able to see us. But we can't see him.
I'm sure he's watching it attentively.
All right.
We can send him the tape.
So is there a motion to,
And I'll second.
okay, all right. So I'd like to read it and thank Paul, I think, who compiled all these wonderful things that Commissioner Galetta has done over the years. Whereas Paul E. Galetta served as Atlantic County's representative on the Pinelands Commission from April 2007 through March 2019, and whereas as a lifelong resident of Hamilton and as the co-owner of the Atlantic Blueberry Company, which is one of the largest producers of high bush blueberries in the world, Mr. Galetta brought a wealth of knowledge and expertise about agricultural issues as well as an important local perspective to the commission. And whereas Mr. Galetta served on the commission's policy and implementation, permanent land protection, public and governmental programs, plan review, memorandum of agreement policy advisory and agricultural committees. And whereas during his tenure, the commission adopted 14 amendments to the Pinelands Comprehensive Management Plan, completed an in-depth review of the plan, and approved 532 public development applications. And whereas during his tenure, the commission contributed $9.4 million towards the permanent protection of 8,769 acres of land in the Pinelands. And whereas Mr. Galetta generosity in donating crates of fresh blueberries to fellow commission members and staff is always appreciated. And Mr. Galetta guided 2 outstanding tours of his blueberry farm during the summertime Pineland short course in Hamilton, along with delivering other educational presentations that raise awareness and appreciation of the Pinelands. And whereas the members of the commission want to recognize Mr. Galetta's significant contributions and express their appreciation for the service that he performed. Now therefore be it resolved that the members of the Pinelands Commission assembled at the Richard J. Sullivan Center for Environmental Policy and Education on this day, 12th day of July, 2019, do hereby express our appreciation to our colleague and friend Paul E. Galetta for his commitment to the Pinelands and for his service as a member of the commission between April 2007 and March 2019. And I also understand, Paul, he'll be doing a tour next
He will. This will be his third. Yeah.
Thursday.
He's graciously agreed to do it again. He really enjoys it, he told us. He's looking forward to doing it. It's a great tour as well.
Any-
Made a motion and second, right?
Yes.
I would, at our last meeting, Chairman Prickett brought up that it was an honor and a privilege to serve as a member of the commission. And I truly believe that also. And I would like to suggest, in addition to a written resolution, that we extend a plaque to those commissioners leaving the commission in appreciation of their service.
Do we need a concurrence up here, commissioners, or?
I support that idea.
Yeah.
Certainly agree.
So this would be not only for Commissioner Galetta, but for any future commissioners that leave the commission. It would be a nice gesture.
Just for, when do you want the cutoff to be? I think we've had a couple that have left recently as well. Do we want to extend that to them?
I think
Also?
so. I think so. In other words, starting in the year 2019.
Upon request. we could go back even further than that.
I agree. Chairman?
Sure.
If you for a minute, I'd just like that. I think that's a wonderful resolution. Looking forward to voting for that in a minute. Just wanted to add to that Commissioner Coletta did a lot to help me understand agricultural issues here. He was a great advocate for those. I think it's wonderful that he does the tours. I've taken the tour, looking forward to doing it again next week with my grandson, who is a huge fan of Commissioner Coletta and the tour. And I'm grateful for the fact that he has, in his tenure here, been a very proactive commissioner. He's really devoted his full-time attention to focusing on the issues that were before us. We didn't have to agree all the time, we certainly didn't, but I was confident that whenever Commissioner Coletta was facing an issue, he would put his full attention to it. He would put his sincere thought behind it. And I'll always be grateful for the effort that he added to what we did here to try to focus on off-road vehicle abuse in Wharton State Forest. And he was very active in that issue, and I really appreciate his support in that. So for many reasons, I want to thank him publicly for his work here and salute him for that. Thank you, Chair.
To that end, as a new commissioner from Atlantic County, Paul has extended to me the courtesy of asking him any questions at any time during the day or night. And, that's quite a contribution in my mind.
I remember Paul always to be interested in topics that we cover, especially agricultural issues. And it was nice to hear, I think he, during the agricultural committee, some of the discussions, he talked about the use of irrigation that limited the loss of water through the hoses and pipes and things like that. So he is a great advocate for farming. And he's also, I think, a great advocate for the environment. I remember he came in one day and he talked about donating land to Green Acres. I guess it was his company that did that. And I thought that was really neat that he and his company was able to do that if that was the circumstance. So he is someone that you can always approach. And I wish I was taking his tour on Thursday, but unfortunately it's going to have to wait till next year. I hope all of you will do it again next year and in future years as well. So are there any other comments?
I'll just very briefly, I mean, I've expressed my respect and admiration for Paul many times, and he served as vice chairman when I was chairman for a while, and echo a lot of your sentiments. He always brought thoughtful insight to all of our conversation, especially as it pertained to agricultural and off-road use. So I continue to keep in touch with him. I consider him a friend, and again, I'll thank him for his service.
Okay, all in favor of approving this resolution, say aye.
Aye.
Always have to speak on behalf of the staff about commissioners.
I'm sorry.
That's okay. And Paul was one of those commissioners who was very engaged. He would call with questions all the time. He did bring us blueberries. That was big. And he also brought us Jay Mounier on a regular basis.
Yes.
Which was also big and a nice thing. But he was a solid commissioner. He was very engaged and very generous with his time. He was a short course, so extends invitations all the time. I still stay in touch with him because he's very helpful on ag issues and honest and good about it. And Hamilton as well, where we struggle. So I've already missed Paul's being here, and he's a good guy.
Well, all the commissioners that have retired certainly are welcome to come back. You know, I'd love to have them come back. And
Like Jack.
yeah, like Jay and a few other commissioners have come back and spoken. So they have a wealth of knowledge that I hope they'll continue to share with us.
And when I spoke to Paul, I did suggest that maybe in the fall, we would have like a group of them come back, since they're probably all not going to be here for this, and have something.
Well, that's a good idea. Okay. So we do not have any public, we do not have public development applications. We have no planning matters. But we do have,
We did. We voted prior to you chiming in.
The only clarification we had is it seemed that when it was framed, it was to adopt the resolution commending Commissioner Gilletta, but it's not necessarily clear if Commissioner Irick's suggestion to add the plaque was added to that or not. So just procedurally, not really clear what that was.
can we do a separate resolution?
Sure. Yeah, and we
We're not
just
adding
need
it
to
to that resolution. That's what you're asking?
Yeah.
No, resolution stands. We're not going to add the plaque. We can just do-
We don't need a second resolution.
I control all things plaque.
So you have a dental degree as well, or?
Not that much.
All right, so I think we have our public comment at this point, do we not? And we have a list of, I've lost my list.
I think you have first is public comment on development applications where the record is not closed.
Thank you, Sean.
Yes.
Exactly.
Sorry.
Okay, so the meeting is now open for public comment on the topics that Commissioner Owen just mentioned.
There's 1, 2, 3, 4, 5, 6, 7, 8, and 8 publics.
Thank you. Where did I lose these at?
It's right on the agenda.
Okay, yes. So, doesn't appear as if there is anyone here today or inclined to talk about, make public comment on any of the 1, 2, 3, 4, 5, 6, 7, 8 public development projects. Going once, going twice. Okay, meeting's closed on that matter. Okay, master plans and ordinances not requiring commission action. We have 2 from Barnegat, and we talked about one earlier. We have 1 from Monroe and 2 from Washington. I found it interesting that a number of those ordinances dealt with flooding. After having as much rain as we have had recently and tornado warnings, I guess municipalities throughout South Jersey are facing those problems. Okay, I'd now like to open up the meeting to general public comment. Ryan, welcome.
Morning. Morning, Commissioners. Thanks for the opportunity. Ryan Greck, Pinelands Preservation Alliance. Just a brief comment today. I had been hoping to get an update from the Commission today about the South Jersey gas matter. It's been since February, since the Attorney General, made the statement that the approval was no longer, that the basis of the approval had been undermined when BL England removed RC Taping Holdings removed BL England from the process. So I was just wondering if there was an update from the Commission. I don't know if you're able to answer that regarding timing or kind of next steps with that plan.
I can share with you that, as you know, we have been discussing a resolution. We did not have quorum today for any such action, so we kick to the next month.
Thanks.
Okay, any other comments? Okay, seeing none, close the meeting to the second general public comment. Do we have a resolution today to retire into closed session? Okay, so we don't need to retire into closed session. Okay, good. All right, Commissioner comments.
Chairman, I just wanted to commend the White Bog Foundation for another wonderful blueberry festival last month. It was really terrific. Can never get enough of blueberry ice cream with fresh blueberries on top. Again, to say I'm really looking forward to the short course next week. It's really going to be fun. So it was a real tough choice between the brewery tour and the ferry tour, but Commissioner Gilletta. That's exactly it. So there you go. But thank you.
I can't believe that Commissioner Lobauer went to the Blueberry Festival and didn't go down to see Charles Beckwith.
Yeah, I'm so sorry.
Charles Beckwith was on the porch. As you may know, I reenact Charles Beckwith at every Blueberry Festival, and I just thought Commissioner Lobauer wasn't there.
I am so sorry. I missed that.
That's okay. All right, are there any other comments?
Make a motion to adjourn.
Uh,
Before you do that, you
Yeah.
have a few comments, I'm sorry.
Yeah. Well, I don't have really comments. I just,
I tried.
not for myself. I would just like to ask Paul to talk about, and Joel, maybe to talk about the short course next week. It's still opportunity for the public to register, I think.
That is correct. And we are within range of previous year's enrollments, but all courses are open. People can register online, they can register by mail, they can register by phone, or they can just show up and register the morning of. We have an excellent lineup. We're hoping for a good turnout. We're hoping for more people to register. If there are people who are listening to this live stream, please give us a call. We're happy to have you. We were recently listed by Rutgers as one of the top education events in the state for teachers, which we're proud to receive that honor. And if anyone has any questions about it, I'm happy to answer it.
So they get continuing education
They
credits?
do. They receive 5 professional development credits. We're registered with the State Department of Education. Yes, PDC, the other PDC.
Great. This is what, the third year?
This is the 3rd year, correct? Mhm. Yeah, so we're happy. Hamilton's been a great host. Stockton is always a good partner in these events. They've been very attentive. Our counterparts of the continuing education program are always doing a good job on our behalf, and they have a lot of good ideas and they execute them. So we're very pleased to work with them.
That's wonderful. All right. I'd also like to mention that before the short course, the Land Use, Climate Impacts, and Sustainability Committee meeting is next Wednesday, July 17th. The agenda is online. It starts at 9:30. And I'd also like to invite elected officials to the July 23rd, 2019 at 4 p.m. here in this room. The Pinelands, that's a Pinelands Municipal Council meeting and Pinelands orientation. It doesn't say elected officials this time, as it has in the past. So, all right, so with that, I'm finished, unless there's anything, any other activities that need to be mentioned. No. Okay, and Mr. Irwin?
My motion to adjourn still stands.
Second.
Okay, all in favor, say aye. Aye. Thank you very much, everyone.